advocate and is a dual qualified in medicine and law, and is a medical doctor turned lawyer, having graduated from the reputed Sun Yat-sen University from People's Republic of China, with an MBBS degree in the year 2011. Later, his interest and passion towards law made him join 3 years LLB course in the year 2013, and he obtained his LLB degree in First Division. That is from MSS Law College, Chadarghat, which is affiliated to Usmania University. Sir has also secured First Division in his LLM course in the year 2021. Sir has also pursued PG Diploma in International Humanitarian Law from Nalsar University of Law, and obtained an A grade in the course. He is also currently pursuing his PhD in law as a part-time PhD research scholar from ITFI Law School, Hyderabad. He enrolled as an advocate on the rolls of Bar Council of Telangana, then composite Bar Council of Andhra Pradesh in the year 2016, and has joined the chambers of his mother, Honorable Mrs. Justice Surepalli Nanda, as advocate as she then was, and practiced in Telangana and Andhra Pradesh High Courts, and gained experience in handling various types of constitutional, civil, criminal, labor, revenue, service and arbitrational matters, and continued in the said office till her elevation as judge, High Court of Telangana, till 2022. He has also assisted his father, Sri Surepalli Madhava Rao, sir, who is a retired principal district. Since he has been practicing since 2022 independently as an advocate. He specialized in constitutional law, criminal law, international law, and service law. He has dealt with writ petition, writ appeals, criminal petitions seeking quashment of FIRs, bail applications, civil revision petitions. He has been invited as moot court judge in various intra-moot court and national moot court competitions. He has also a prolific author in the field of law, and about 26 articles and research papers authored by him, which has been published in various regional, national and international law journals. To mention, he has been authored with WTO in a post-COVID world, the crisis of the rule-based trading system, a WTO reform. And also the second book, Role of Supreme Court of India in Protection of Women's Rights, a critical study, which was published in the year 2024, both the books. He has also qualified in TS set, that is Telangana State Eligibility Test, which was conducted by the Telangana government for post of assistant professor. He has been appointed as the special assistant public prosecutor in the High Court for the state of Telangana. He has been continuing as such on date. As special assistant public prosecutor in the High Court of Telangana, he has gained experience in dealing with various criminal matters, including criminal appeals, bails, criminal petition to quash FIRs and charge sheets, criminal revisions, etc. He has also been appointed as Central Government Counsel in the Telangana High Court and has been continuing as such as on date. So it gives me immense pleasure to introduce you with such a vast academics and so much of vast experience. So it is our privilege to hear from Sir about the FIR and quash petitions. Over to you, sir. Thank you. I invite Sir now.
Good afternoon to everyone. First, I thank the organizers, P.R.Foundation, who have organized such a useful workshop for the upcoming young lawyers who will be the next generation, the backbone of our legal system, whether in the district judiciary or in the High Court, and in the decades to come, maybe even in the Supreme Court as well. So I heartily congratulate him, and I've been seeing the lectures since morning and the participation also, and everyone has been, the galaxy of judges who address the gathering speaks volumes about the efforts being put in by this foundation. Coming to my topic, I have been given two topics. One is quash petitions and criminal appeals. So, coming to quash petitions, first, what do you mean by quash petition? Quash petition is filed to stop a criminal case, a criminal proceeding, even when there is a trial which is to commence. So even before the trial commences, also even before is acquitted or convicted, once the High Court quashes the criminal case, it is stopped. The crime is also, it comes to a full stop. So a quash petition is filed under section 482 CRPC and under 528 in the BNSS. 482 and 528. So what are the grounds for which a quash petition should be filed? In this case, regard, I should stress upon the landmark judgment of the Supreme Court, which every lawyer, criminal lawyer, should know who files a quash petition in Supreme Court. That is Bhajan Lal, State of Haryana versus Bhajan Lal. So in this judgment, the Supreme Court mentioned 7 categories in which FIR can be quashed. One, the number one is allegations in FIR, if accepted as true, do not prima facie constitute an offense or make out a case against the accused. Number two, allegations and materials do not disclose a cognizable offense, not justifying an investigation by the police. Number three, the allegation and evidence do not disclose the commission of any offense. Number four, the allegations constitute a non-cognizable offense and no investigation can be conducted, no investigation can be conducted by the police without a magistrate's order. Number five, the allegations in the FIR are so absurd or inherently improbable that no reasonable person would conclude that there is sufficient ground to proceed with the case. Number six, there is an express legal bar preventing the institution or continuation of proceedings. And number seven, the criminal proceedings are motivated by malafide intentions or are maliciously instituted for personal reasons. So these are the 7 categories in which FIR can be quashed, and this is the gold standard for every criminal lawyer in quash who wants to file a quash to know that these 7 categories, whether your case falls under that or not. In this regard, I would like to give an example. The Supreme Court in the recent case of Mohammad Wajid versus State of UP. In this case, what happened was FIR was lodged against the accused persons alleging offences punishable under sections 394, 504, 506 and 323 of IPC. They approached the apex court. As Allahabad High Court, they refused to quash the FIR. So on the issues, the Supreme Court had to decide was whether it falls under any of the parameters, 7 parameters laid down in State of Haryana versus Bhajan Lal to quash the criminal case. So the Additional Advocate General who appeared on behalf of UP government argued that the FIR can't be quashed and there are gross criminal antecedents of the accused persons. So gross criminal antecedents means he has a previous history of cases, criminal cases which are maybe 3 or 4 or 2 or 3, which are merit that it should not be quashed. But the Supreme Court held that a bare look at the chart may give an impression that appellants are history cheaters and ardent criminals. However, when it comes to quashing of the FIR or criminal proceedings, the criminal antecedents of the accused cannot be the sole consideration to decline to quash the proceedings. An accused has a legitimate right to say before the court, howsoever bad his antecedents may be, still if the FIR fails to disclose commission of any offense or his case falls within the parameters laid down by the Supreme Court in Bhajan Lal, the court should not decline to quash the criminal case only on the ground that the accused is a history cheater. And so the Supreme Court overturned the judgment of the Allahabad High Court and quashed the FIR. This is the case of Mohammad Wajid versus State of UP. This was in 2023. And one more important case I would like to stress, which every quash lawyer should know, is the Niharika infrastructure versus State of Maharashtra. This is also another important judgment by the Honorable Supreme Court. In this case, the Honorable Supreme Court held that criminal proceedings should not be quashed at the investigation threshold or at the crime stage, and only in the rarest of the rare cases should a crime be quashed. This is what the Supreme Court held in the Niharika Infrastructure Private Limited versus State of Maharashtra, in which the Supreme Court held that there is no blanket rule, but with circumspection, the High Court should exercise their power in quashing the criminal in the crime. So, one more aspect, important aspect while dealing with quashes, every lawyer should know is, because if the investigation is at a nascent stage or is it advanced stage, should the High Court quash an FIR? What do you all say? If the investigation, if they have filed a charge sheet already, can the High Court quash the crime? Yes. The Supreme Court held that even after charge sheet is filed also, the High Court can exercise the power to quash the FIR. And the Honorable Supreme Court held so in the recent judgment of Imran Pratap Gadi versus State of Gujarat. This was in 2025. The judges were Justice Abhay S. Oak and Justice Ujjal Boyan. They held that when the High Court in the given case finds that no offense was made out on the face of it to prevent abuse of the process of law, it can always interfere even though the investigation is at the nascent stage, and it is all depends on the facts and circumstances of each case as well as the nature of the offense. So what happened in this case, Imran Pratap Gadi versus State of Gujarat, was an FIR was registered in Jamnagar, Gujarat against Pratap Gadi under sections 196, 197, 299, 302 and 57 of the BNS. So what is 190? It mainly deals with offences relating to enmity between different groups on grounds of religion, race, place of birth, residence. Supreme Court observed that mens rea must be read into section 196 BNS, and it was impossible to attribute any criminal intent to Pratap Gadi, and a mechanical exercise of power amounted to clear abuse of the process of law, and the FIR, such an FIR virtually borders on perversity, and criticized the court for not quashing the FIR. And an important case is Kailash Bain, Mahendrabhai Patel and others versus State of Maharashtra and others. In this case also, the Supreme Court held that there is no prohibition against quashing criminal proceedings even after charge sheet has been filed. So, the Supreme Court bench comprising Justice P.S. Narasimha and Pankaj Mittal held that while quashing the domestic cruelty case against the accused, they saw that no new allegations were discovered against the accused even after filing a charge sheet, as it remained the same as recorded in the FIR. So when you deal with quash petitions, you should always make out a case whether it attracts the ingredients of the offense and whether there is a prima facie case made out or not. That you will see by looking into the complaint and then the statements of the witnesses, if any. All these will be you should look into and then argue before the court that you have a strong ground for quashing of the crime. Even after charge sheet is filed also, your case is maintainable. So what I was telling about Niharika infrastructure versus State of Maharashtra was, that time the Supreme Court addressed the issue of interim orders issued by high courts under 482 CRPC. So many high courts were issuing interim orders that no coercive steps should be taken against the Supreme Court held that no coercive steps should not be a routine, and there should be judicial restraint. And when there are allegations and there is prima facie case and adequate reasoning, the court should not impede the police's statutory duty to investigate cognizable offences. So the Supreme Court relied on a plethora of decisions and held that interim orders for no coercive steps to be taken should not be issued as a blanket rule. And one more important case is Kim Wansu versus State of Uttar Pradesh and others, reported in 2025 Live Law SC7. So whether can the Supreme Court or the High Court quash a criminal case under 482 can also exercise powers under Article 227 of the Constitution? What do you say? Can it use its powers under Article 226 of the Constitution to quash the criminal case? The Supreme Court held that yes, it can. Normally, quashing of criminal proceedings would be done under the inherent power under Section 482, but that does not mean that it can be done only in 482, but under Article 226 also, the Supreme Court can, in exercise of writ jurisdiction, quash the criminal case. That time, the judges of the Supreme Court were Justice C.T. Ravi Kumar and Justice Sanjay Kumar, who was from Telangana High Court. They were hearing a criminal appeal against the Allahabad High Court's decision that refused to quash the criminal case against the appellants in exercise of writ jurisdiction under Article 226 of the Constitution. The appellant that time was a manager of a company, Hyundai Engineering and Construction India LLP, and he was implicated in the affair, saying he had cheated. The allegations of cheating, fraud, and criminal conspiracy was made in the complaint relating to payment defaults totaling 9 crores. And there will be many cases in quash, you'll know, such as there will be one case and there will be a counterblast FIR, one FIR and another counterblast FIR. So that time, Supreme Court has also held that there should be a delicate balance between private liberty and public interest. In the case of Nitin Ahluwalia versus State of Punjab and another, in 2025 INSC 1128, reported in 2025 INSC 1128, it was a recent judgment on 18 September 2025. The Supreme Court quashed an FIR under Section 498A IPC filed by a wife after adverse decrees in foreign courts relating to divorce and custody. The court found that the FIR was a counterblast and its continuation would constitute abuse of process. The Supreme Court judges, comprising Justice B.R. Gavai and Lordship Justice K. Vinod Chandran, emphasized that the timing of the FIR and the surrounding matrimonial litigation indicates there's a counterblast case, retaliation and counterblast FIR, and they are clear markers of malafide intent, and they quashed, the Honorable Supreme Court has quashed the criminal case. And also, the Supreme Court has also in many a time has held there will be a civil dispute, cheating or criminal breach of trust, and they give it a criminal flavor. It's a X, Y, Z, X, Y, and Y, they have a dispute, and X files a suit and then seeking suit for recovery of money, or then later he fails to repay, then he resorts to criminal proceedings. The Supreme Court held that this amounts to a civil process taking a criminal flavor, and it cannot be, civil debts cannot be enforced through criminal process, and it has told, the Supreme Court has directed the high courts that you should not engage in settlement engineering under Section 482. So civil disputes which undertake a criminal flavor are to be quashed, is what the Supreme Court has held. One more important case I would like to deal with is whether if there is a delay in registration of FIR, does it mean that the case should be quashed? Suppose X has lodged a complaint. Incident offense has taken place 3 months prior or 1 year prior to the what he has lodged. Should the FIR be quashed on this ground that there is a delay in FIR lodging of complaint? What do you say?
Yes. Yes, but explain why the
Supreme Court has held that if the delay in registration of FIR is not the only ground to quash an FIR. In fact, in the case of Puneet Beriwala versus State of NCT of Delhi and others, the Supreme Court held that delay in registration of FIR for offences punishable for more than 3 years is not a ground to quash FIR if the same discloses the commission of a cognizable offence. So cognizable offence means the police can arrest without a warrant. So if the same discloses a cognizable offence for offences punishable in 3 years, then it is not a ground to quash the FIR. The judges were Justice Dipankar Datta and Justice Manmohan, and the offences were under section 467, 468, 471, 420, 120B of IPC. So all these provisions describe a punishment of more than 3 years. And the Supreme Court held that it is settled law that delay in registration of FIR for offences punishable with imprisonment of more than 3 years cannot be the basis of interdicting a criminal investigation. So with this, I have just given you next topic. Coming to my next topic is about criminal appeals. Yes.
FIR, usually when we file a charge petition at the stage of FIR before filing the charge sheet, then PP always says that let the charge sheet be filed and investigation has to be done. On that time, how should we counter that point?
You have to argue before the court that even if charge sheet is filed, we have a prima facie case, offences are not made out as per the complaint and as per the FIR. Contents of the complaint, contents of the FIR do not make out a prima facie case, and you should support it by citations. Case law is very important here. So any case law which supports your case, you should bring it to the notice of court and then argue before the court. Argue means convince the court. Persuasive advocacy is very important, not threatening advocacy. So persuasive advocacy with help of citations, as I just shared, you should tell that even if after charge sheet is filed, my criminal petition for quash is maintainable. Supreme Court has held so in so and so cases, and argue it.
Sir,
Yes.
can we file in the lower courts?
No, lower court you cannot file quash. It is only 482 CRPC and 528 BNS are inherent power of the High Court only. It's only the High Court which has the power.
Circumstances now based on this or the completion of the
I'll complete my next topic and then you can ask questions. Coming to criminal appeals. So what is a criminal appeal in High Court? It is under 389 CRPC, 389(1) CRPC or 430 of the BNSS. So criminal appeal is a legal proceeding in which a High Court reviews the decision of a lower court in a criminal case. The purpose of an appeal is to determine whether the lower court made any errors in law or fact that affected the outcome of the case. And an appeal is not a retrial, and the High Court does not hear evidence or call witnesses. Instead, the High Court reviews the material on record from the lower court and considers the arguments on both sides. So this is what is done in High Court. So there in High Court, criminal appeal, you do not have witnesses' statements being recorded or evidence being reheard. It's only the material, lower court material on record, and also the arguments from both sides, and then the court gives its verdict in the criminal appeal. So appeal can be appeal against conviction and also appeal against acquittal. If it is an appeal against acquittal, the state prefers the appeal. If it is an appeal against conviction, the convict or the accused prefers the appeal. And one thing you should always remember, appellate court, that is high court, cannot dismiss the appeal in default, but must dispose the appeal on merits on perusal of the record, even when the appellant or his counsel does not appear to press or prosecute the appeal. There is no provision in CRPC for dismissing the appeal or in BNSS for dismissing the appeal in default. So it has to be a reasoned order, it has to be on merits, on perusal of the record, and the appellate, just because the counsel has not appeared, the appellate court cannot dismiss the appeal in default. The important case law in this point is Shyamdev Pandey versus State of Bihar. This was reported in AR 1971 SC 1606. And in dealing with a criminal appeal, you should know a few important things. What is last seen theory? What is circumstantial evidence? What is last seen theory? Last seen theory is the theory in which when the accused was last seen in the presence of the deceased before the crime occurred or the offense occurred. So last seen theory is important principle in criminal law in which criminal appeals are decided, and it is derived from Section 7 of the Indian Evidence Act. Last seen theory is derived from Section 7 of the Indian Evidence Act, and the person who was last present with the victim would have a reasonable opportunity to commit the crime. That is the understanding behind this theory. So the presumption of fact is taken under Section 114 of the Indian Evidence Act, under which the court presume that certain facts exist if some other facts are proved to be existing in the case of natural events, human conduct, and public and private business. So last seen theory is important along with eyewitnesses. Whether first thing when you argue a criminal appeal, which the judge asks, what I'm telling from my experience, I've argued before Honorable Justice Lakshman Sir's division bench for the last 1 year. And the first question the judges ask is, are there any eyewitnesses to the incident? If there is eyewitnesses are there, whether they were examined in the chief and cross examination. And what about the medical evidence, medical and forensic evidence? These are all important things in arguing a criminal appeal. Last seen theory. And what about circumstantial evidence? Some cases there is no direct evidence and it rests on circumstantial evidence. So what are the circumstances which unerringly point to the guilt of the accused and form a complete chain? That is circumstantial evidence. So all these are important when you argue a criminal appeal before the High Court. And you have to remember few important cases which are important in your daily practice if you deal with criminal appeals. One is Sharad Birdichan Sarda versus State of Maharashtra. This was reported in 1984, 4 SCC 116. So this case was dealt by a 3-judge bench of the Supreme Court and laid down 5 golden principles for circumstantial evidence. Punchil of the proof of a case based on circumstantial evidence. Number 1, the circumstances from which the conclusion of guilt is to be drawn should be fully established. Number 2, the facts so established should be consistent only with the hypothesis of the guilt of the accused, that is to say, they should not be explainable on any other hypothesis except that the accused is guilty. Number 3, the circumstances should be of a conclusive nature and tendency and unerringly point towards the guilt of the accused. Number 4, they should exclude every possible hypothesis except the one to be proved. Number 5, there must be a chain of evidence so complete as not to leave any reasonable ground for the conclusion consistent with the innocence of the accused and must show in all human probability the act must have been done by the accused. So these are the 5 golden principles which are important for any case which rests on circumstantial evidence when there is no direct evidence. Sharad Birdichan Sarda versus State of Maharashtra. Coming to where an individual's conviction for murder was taken in appeal to the Supreme Court, holding that the prosecution case rested solely on circumstantial evidence and last seen theory, and there is no other corroborative evidence. What did the Supreme Court say? The Supreme Court held in Manoj Munna was State of Chhattisgarh that what was the case about? The case pertained to the brutal murder where deceased body was found with multiple injuries, including ligature marks and severe burns. The prosecution's case rested entirely on circumstantial evidence. That is, theft of a tractor for money and the last seen theory. That means the accused was last seen in the presence of, in the company of the deceased. So witness had testified that appellant and co-accused were seen taking the deceased on motorcycle and the deceased was never seen alive. The trial court convicted the appellant. High Court confirmed it and relying primarily on last seen and the appellant's failure to explain when he parted company with the deceased. Supreme Court set aside the Chhattisgarh High Court's decision solely because it relied only on the last seen account with the deceased and held that a conviction cannot be recorded against the accused merely on the ground that the accused was last seen with the deceased. And the High Court of Chhattisgarh had committed a mistake in putting entire burden of proof upon the appellant under Section 106 of the Evidence Act when prosecution has not discharged its initial burden of proof to successfully prove the chain of events linking accused to the crime. So Section 106 of the Evidence Act comes into operation only in situations where the prosecution has already established a reasonable inference against the accused. And so the Supreme Court set aside the Chhattisgarh High Court judgment and allowed the appeal. And one more important aspect, dying declaration. Dying declaration is a very important part in dealing with criminal appeals. If there is a dying declaration, what is a dying declaration? Anybody? Yes. Yeah, dying declaration, before he dies, what he is reported to the police or a doctor or a magistrate, that is a dying declaration. That is under Section 32 of the Evidence Act. So, Supreme Court held in the case of Rajendra, son of Ramdas Kole versus State of Maharashtra. Supreme Court held that dying declaration can be the sole basis for conviction and does not require any further corroboration. The law, once a dying declaration is found to be authentic and inspiring confidence of the court, it is reliable, it is genuine, then the same can be relied upon and can be the sole basis for conviction without any corroboration. Means without any supplementary evidence, any additional evidence, without any corroboration. That's what the Supreme Court, because if the court is satisfied that the dying declaration was rendered voluntary, reliable, consistent, then, and it is not with any tutoring, then it can be the sole basis of conviction. This was held, important case, Rajendra, son of Ramdas Kole versus State of Maharashtra. This judgment was delivered by a bench of Justice Abhay S. Oak and Justice Ujjal Buyan of the Supreme Court. And when a motive, there is a motive element also in a crime, in a murder, motive for committing the murder, motive for financial gain in committing the murder. So whether motive is significant factor in the confirming the conviction or acquittal or setting aside the order of acquittal, Supreme Court what it held that motive is insignificant when direct evidence exists. Simply because there is no motive does not mean that accused cannot be convicted when there is direct evidence. In the case of state of Himachal Pradesh versus Chaman Lal, this is in 2026, Supreme Court restored the conviction of a man for committing murder of her wife, observing that absence of motive is not fatal to the prosecution when there is clear, credible, and direct evidence such as dying declaration. Motive assumes significance primarily in cases based on circumstantial evidence, where there is direct evidence in the form of a credible and trustworthy dying declaration. The absence of proof of motive is not fatal to the prosecution case. This was held by a bench of Justice P.V. Nagaratna and R. Mahadevan. They set aside the Himachal Pradesh High Court decision which acquitted the accused and restored the conviction. So, one more important point. Eyewitness account, that is ocular evidence. If ocular evidence, oral evidence, and medical evidence, three evidences, which evidence is the best to sustain a conviction according to you? Medical evidence, oral evidence, ocular means eyewitness evidence. Medical evidence, oral evidence, ocular evidence, eyewitness evidence. Which is the best to sustain conviction? So, the Supreme Court has held that ocular evidence is the best evidence unless there are reasons to doubt it. So, even this, in the case of Prithviraj Jayantibai Vanol versus Dinesh Dayabai Wala in 2021, Supreme Court held that ocular evidence is the best evidence unless there are reasons to doubt it. That is, eyewitness account is the best evidence, even if the medical evidence makes the ocular testimony improbable. Even if the medical evidence makes the ocular testimony improbable, the ocular evidence being true, it is the best evidence. It was held by a bench of Justice Naveen Sinha and R. Subhash Reddy. And in this case, the High Court reversed the trial court order convicting the accused on the ground that the evidences of eyewitnesses is inconsistent with medical evidence regarding nature of injuries and the weapons of offense. The bench, referring to evidence on record, addressed the contention that identification was not possible in the night to give them the benefit of doubt. So even low applicability of light, that is not the sole ground to look into while confirming a conviction or setting aside an acquittal. So, eyesight capacity of those in rural areas is far better than town folks. Identification at night between known persons can be possible by voice, movement, gait. So, that's what the Supreme Court held, and it has held that eyewitness account is the best evidence, and only if there is lot to doubt to the evidence of eyewitness can the evidence of eyewitness be disbelieved. Even if medical evidence supports, eyewitness is the best evidence. Coming to a POCSO case, if there is a testimony of a victim in a POCSO case and there are no other, if PW2 prosecution witness is the PW2 is the victim and she is the only sole testimony of the crime of sexual assault committed on her, can it be taken as insufficient when there is no other evidence, corroboration or other material to take into account? If our deposition, if our victim deposition is enough for conviction, what do you say? It's not dying declaration. POCSO case. POCSO is Protection of Children from Sexual Offences Act. So in that case, it's not a murder case. So it is a POCSO case. POCSO case, Supreme Court held that testimony of a victim, sole testimony of victim prosecutrix, if it is reliable and trustworthy, trustworthy, it can be enough to convict the accused. Even if there is no other evidence, if he's a victim, if she is not tutored, if she is speaking the truth and is consistent, reliable, cogent, then Supreme Court held that sole testimony of the sexual assault victim, if is reliable and trustworthy, can be the basis for conviction. It was held in the case of Ganeshan versus State. Ganeshan was convicted for sexual assault on a girl aged 13 years and was sentenced to undergo 3 years rigorous imprisonment. Before the apex court, he contended that the trial court had committed a grave error in committing the accused, relying upon the sole testimony of victim, and pointed out that the mother of the victim did not support the case of prosecution and did not support the deposition of the victim. So the bench, the 3-judge bench comprising Justice Ashok Bhushan, M.R. Shah and Subhash Reddy said that the mother of the victim had turned hostile, but the victim had fully supported the case of the prosecution. She had narrated in detail how the incident had taken place. She had been thoroughly cross-examined, and there is no other reason not to rely upon the deposition of the victim. And she was aged 15 years at the time of deposition, and so she was mature enough to know what she was saying. So, conviction can be based on sole testimony of victim if she is found to be reliable and trustworthy. So, in case of related to, there is a weapon which has been recovered from the scene of offense and it was produced. Can recovery of weapon be linked to the crime? Linked to the crime and convict the accused? What do you say? So, as per Section 27 of Evidence Act, the Supreme Court held recovery of weapon is meaningless without proof linking it to crime. Supreme Court in the case of Gautam Satnami versus State of Chhattisgarh in 2026 had set aside the murder conviction after finding that the prosecution's recovery of evidence based on the accused disclosure statements under Section 27 of the Evidence Act were riddled with inconsistencies, hostile witnesses, and lack of forensic linkage. And one more important case, a witness deposes, then he turns hostile. What do you mean by hostile witness? Anybody?
Somebody said, I don't know who is the accused.
Who retracts from his statement. A witness who retracts from his or her statement. He says something now, then he goes back on that. That is hostile witness. Whether testimony of hostile witness can be considered to convict accused. Supreme Court Constitution Bench, that is a 5-judge bench, in the case of Neeraj Datta versus State of National Capital Territory of Delhi in 2022 held that this is very important, that there is no legal bar to raise a conviction upon a hostile witness testimony if corroborated by other reliable evidence. So in this case, a witness had been declared hostile, but Supreme Court held that does not result in automatic rejection of his evidence. Because in the case related to a Prevention of Corruption Act case based on circumstantial inferences, there in the absence of direct evidence regarding demand or giving of bribe, there can be conviction, is what the Supreme Court held. Just this Supreme Court held, even if a witness is treated as hostile and is cross-examined, evidence cannot be written off altogether but must be considered with due care and circumspection. And that part of the testimony which is creditworthy, that part which is useful, must be considered and acted upon. So it's not that just because they are turned hostile, that does not mean that witness testimony can be discarded. Hostile witness testimony, to the credit, how much it is creditworthy, can be considered to convict the accused. And one more important aspect. there will be A1, A2, A3, A4. Suppose A5, 5 accused are there in a crime. Can co-accused statement A5 will give a statement to the police saying that A6 is also involved. Based on that, the police bring A6 also into the crime. Can this confession of a co-accused be relied upon as a substantive evidence and be taken into consideration for convicting the accused? What do you say?
Depends on evidence. Substantial evidence can be created. Depends on evidence.
So Supreme Court held that in the case of Subramania versus State of Karnataka, extrajudicial confession of a co-accused cannot be relied as substantive evidence. The confession of a co-accused could be used only in support of evidence and could not be the foundation for conviction. So it should not be the foundation for conviction and only supportive part, but cannot be the sole part for, in the absence of other evidence, just because he has confessed extrajudicial confession of a co-accused, it cannot be relied upon as substantive evidence. The judges were Justice U. Lalit and Patiwala. They allowed the appeal filed by a murder convict. Murder accused was acquitted by the trial court, but the Karnataka High Court allowed the appeal filed by the state and convicted the accused. The High Court had relied on extrajudicial confession made by one co-accused to convict the accused. One of the contentions raised in appeal before the Apex Court was that the High Court committed a serious error in making extrajudicial confession as the basis and thereafter going in search for corroboration. And one important, this is what I want to say about criminal appeals. One important case which I have dealt with as a counsel, that case I would like to share with you. This is the case between case law is Gurrala Prabhakar versus State of Telangana, criminal appeal number 92 of 2024. I had appeared in this case. The date of judgment was 10th December 2025. So this was an appeal challenging a judgment in the Sessions Court passed by the fast track special judge of POCSO cases, Mitchell Malkajgiri. So what was the case? The trial court convicted the accused for offences under section 448 and 506 and 42 of the POCSO Act and sentenced him to undergo life imprisonment and pay a fine of 5,000 for the offence. Pay a fine of 5,000 and default to undergo simple imprisonment for a period of 2 months for offence under section 42 of the POCSO Act. So it was a case of a rape on a minor girl by the appellant. And our case, that is a prosecution, as a prosecutor, what my case was, PW2 was the victim and daughter of PW1, and PW3 and LW6 were our grandparents, and PW4 was member of the Child Welfare Committee, Rangareddy district, and PW5 was the circumstantial witness. And the accused was working as a security supervisor and uncle in relation to the victim girl, PW2. So when the victim girl was alone on 12/4/2015, when her mother and brother went to church and grandparents were out of the house, the accused came to her house and asked her to give Aadhaar card. When the victim girl went inside the bathroom, the accused entered the room and forcibly committed rape on her and threatened her not to disclose the matter. So when she felt the pain on 24/2015, she informed her mother, and her mother informed the matter to her in-laws. Subsequently, as there was no response from her in-laws, the mother reported the same to the Child Welfare Committee through PW5, who in turn lodged a complaint with the police, Kushaigoda police station, and a crime was registered against the appellant. So trial court framed charges and ultimately against the accused and proceeded with trial. PWs 1 to 9 prosecution witnesses were examined. Exhibits P1 to P10 were marked, and no evidence, oral or documentary, was let in on behalf of the accused. After completion of evidence, accused was examined under 313 CRPC. So PW 1 to 3 and 8 turned hostile and did not support the case of the prosecution. trial court did not consider the said aspect. FSL report, this is also very important. In POCSO cases, FSL report and medical evidence are very important. I have come across some cases wherein the FSL report, as a medical doctor also, I have a background in clinical MBBS after studying medicine. So the FSL report says there's no semen found or there's penetration. So just because there is no semen, it is sufficient. If there is slight penetration, that is sufficient to make a case for conviction of the accused. FSL report and medical evidence should play a vital role in making the corroborative part for supporting the case of the prosecution. So I had submitted, PW2 was a direct witness to the occurrence. PW2 gave direct eyewitness account, and there is medical evidence, forensic report, FSL report, medical evidence on record also says that there had been penetrative sexual assault, and chief examination also. Whenever you argue a criminal appeal, not go to the trial court judgment first. You should go to the depositions. First, you have to go to what are the PW prosecution witnesses which support the case or support your case. What are the discrepancies in the chief and the cross examination? Those are important. You should not directly go to the trial court judgment. Trial court judgment we should go at the last. So when you argue a criminal appeal, you should always remember to go through the depositions first. And that's how the court had convicted the accused, and in the High Court also the Honorable High Court relied upon the testimony of PW2 victim girl and also the medical and forensic evidence, and had upheld the judgment of conviction on the accused. So while dealing with POCSO cases, one more important aspect is that age of the victim. If the age, Supreme Court has held recent judgment of Rajni versus State of Uttar Pradesh, Supreme Court held documentary evidence like school certificate or birth certificate must be given primacy over medical opinion when it comes to age determination, if the documentary proof is valid and credible. So on record, school certificate, birth certificate, documentary evidence, if it proves that she was below the age, it should be given primacy, and only if there is a discrepancy or a doubt regarding the birth certificate, genuinity of the birth certificate, school certificate, then only age determination or medical opinion or ossification test should be done. So I thank everyone for the patient hearing, and I thank the organizers for giving me this opportunity. Anybody has any questions?
Usually, POCSO cases, 50%, I have seen more than 50% cases are false cases, because they use the law like the victim statement, it doesn't require below 7 years or below 10 years. So with the help of mother, they file a false POCSO cases, then they usually do the settlement. So how should we tackle such cases, sir? For question.
This is an appeal, criminal appeal you are asking?
This is in question.
In quash. Generally, what the Supreme Court and what the law says, POCSO cases, quash, generally Supreme Court has held it should be circumspect in quashing the case. It is only after the material is prima facie, in quashing it's only prima facie case which is looked into. In appeal, all the evidence and all the documentary evidence, medical evidence, FSL, everything is looked into. So there is a difference. What the Supreme Court held that unless it is manifestly evident that prima facie case of POCSO is not made out, then it should not quash the case. That's what is. Yeah.
In POCSO cases, the A4 has been marked as absconding, but A1 even A1 has died, A2, A3 get convicted and they released for on bail. So it's a, but in the entire deposition, there is no mention of ever anywhere regarding A4. Still, the warrant has been issued against.
You have to challenge it in the High Court. You have a good ground on that.
Another last answer.
Yes.
Regarding dying declaration, recently I have seen one case. The girl age is 12 years, and the remand case diary which I read from some sources, they mark as dying declaration, but she is still alive. So it can be a dying declaration or something else.
That is a miscarriage of justice that should be brought to the notice of the court, because dying declaration, when it is recorded, is a recorded on after on it is made on part of the record. That cannot be a false dying declaration.
That only does.
The question is there any
maintainability? The question is about the maintainability of a quash petition. And here is the case. The FIR has the accused, but in the final report, he has not been placed. So can we still quash the FIR?
I not understand your question. What? Come again.
Okay, in the FIR, he is accused.
Yes.
But in the charge sheet, he is not there. Can we still quash the FIR?
If he is not, that is a defaulty investigation or a mistake, because if FIR it is mentioned, generally they make it in the charge sheet, they mention that he is an accused. Only after investigation is done do they file and report.
In the final report,
Yes.
he has been exonerated.
Then it can be a ground for quash.
It can be, right?
Yes.
hostile witness go on manipulating, how we can deal with that?
Hostile witness manipulation, that's part of, we are all human beings. So not all five fingers are not the same. So every person's psychology is different. So we should understand how much part of a hostile witness testimony can be taken into consideration. If it is truthful, how much part can be taken into consideration. That's
Question answers will be concluded. We have another session. Another two sessions are there. Please forward the organization.
Thank you, sir. We thank you for your enlightening address. It was a clear exposition of key rulings of bail and quashing of FIRs, which has made our understanding on the liberty and justice. So thank you, sir. And your valuable guidance will help our junior advocates in the bar practice. Thank you so much, sir. May I now invite our dignitary, our esteemed guest, Shri Ramesh Chandra Gaud, sir, to welcome on the dais, sir. I request the member of the committee to welcome sir with a warm welcome. As a token of gratitude. May I now request the founder of P.R.Foundation, sir, to please felicitate Prashant, sir, for his valuable time, patience, and as a token of gratitude, I would request sir to felicitate, and before that, a message of a word of thanks. Thank you, sir.
So first of all, I would like to gratitude from my organization. When I asked to speak on the criminal practice about the quash petitions and criminal appeals before the Honorable High Court, sir is graciously accepted our invitation and given us such a good time for us to learn things. And it is necessary for the young advocates. Without knowledge, we can't before the high courts. We can't succeed at anything. Knowledge is important here to practice. So hence that, thank you, sir, being as a special public prosecutor, assistant public prosecutor, and giving such valuable time for us to insightful knowledge for us. Thank you. A small appreciation memento may be given.